Oh, hey guys. Okay, now we're going to look at James Vituscka's complaint against the Daily Mail. My starting point is I have not read this at all at this point, nor have I watched any other content creator's video about it. So the only knowledge I've had so far that kind of gives me a very brief summary of what it kind of contains is two comments from Roses Wild on another video yesterday. Thank you very much, sweetie. So I am looking forward to reading this actually, just based off those comments. Again, everyone knows what I think of James Vituscka in relation to the part he played in the Lively Wayfarer lawsuit. I did not think much of him. I thought he changed his mind, changed his story when the wind changed. But, as I said yesterday, I'm prepared to read this with an open mind, hear him out, because if he was pressured to, deliver a specific narrative, then, I want to know about that. So I'm prepared to read this with an open mind and just, digest it and follow the case, obviously. Because, like him or not, that whole debacle over what Leslie Sloan did say or didn't say, and whether he did allow his text to be, included in the lawsuit, which at the end of the day, if you're going to hand over your text to an attorney who's, seeing a lawsuit, you kind of got to expect that they are going to end up in that lawsuit. You don't say, oh, here's my text messages, and then say, you can't then just say, but you can't include them in the lawsuit. Like, what's the point then? You either give an information because it's relevant, and you accept then that they will be part of the lawsuit, or you don't. And it's as simple as that. But the chances are is because he'd already opened his mouth, he was going to be subpoenaed whether he handed over the text messages voluntarily or not. Okay. I'm hoping there's not too much background noise. I've got my fan on because we are and I just cannot get through, without something blowing some wind around me. Okay, so James Vituscka. Okay. Plaintiff, by and through his attorneys, upon information believed, complains of defendant Mail Media Inc. individually and doing business as Daily Mail. Okay, so this is in the Supreme Court of the State of New York. That's the same venue that the New York Times case against Wayfarer was. It's also where the Stephanie Jones case against Abel started before it was moved into federal court. Okay, so nature of the case. Defendant Daily Mail publicly portrays itself as one of the largest and most influential news publishers, renowned for its agenda-setting exclusive commentary and in-depth investigations. Despite that public image, defendant Daily Mail sought to control what one of its own reporters could say in connection with federal litigation and retaliated against him when he repeatedly objected. Plaintiff, a successful investigative reporter, objected to signing a sworn declaration that he reasonably believed contained false and misleading statements for use in federal litigation, sought to perverse his ability to testify truthfully pursuant to a lawful subpoena, and attempted to retain independent legal counsel to protect his individual interests. Rather than respect those efforts, defendant Daily Mail retaliated against him as set forth below. Defendant Daily Mail's retaliation was deliberate and escalating. It discouraged plaintiff from obtaining independent legal counsel, pressured him to sign a sworn declaration despite his repeated written objections, interfered with his participation in a judicial proceeding, stripped him of his reporting responsibilities and bylines while his professional reputation was publicly attacked, and ultimately fired him just 11 days after receiving correspondence from his counsel. Dependent Daily Mail's retaliation did not arise in isolation. Months earlier, after plaintiff rejected a supervisor's sexually suggestive advance, that supervisor's treatment of plaintiff changed materially. As alleged below, that hostility resurfaced throughout the events giving rise to this action and culminated in plaintiff's termination. Plaintiff complains pursuant to the New York State Executive Law, the Administrative Code of the City of New York, the New York Labor Law, Section 740, and the New York Common Law, seeking damages to redress the injuries he has suffered as a result of being discriminated against on the basis of his sex and actual and/or perceived disability, together with creating a hostile work environment, retaliation, whistleblower retaliation, sexual harassment, interference with a protected right, and unlawful termination. Okay, just a quick comment on where we are so far. So sexual harassment. Okay. What I will say here is, right, as much of a liar James Vituscka was during the Lively Wayfarer case, in my opinion, because of the constant changing of his stories, I still already find his sexual harassment and retaliation allegations far more credible than ever did for Blake Lively, which is a wild position to be in. Plaintiff is a male resident of the state of New York, County of Kings. At all times material, Defendant Daily Mail was and is a foreign corporation duly incorporated under the laws of the state of Delaware. At all times material, Defendant Daily Mail was and is authorized to conduct business in the state of New York and does conduct business in the state of New York. At all times material, Defendant Daily Mail operated a U.S. publishing business for the Daily Mail newspaper and website, maintaining its principal place of business at 51 Astor Place, New York. At all times material, Defendant Daily Mail was and is the US-based subsidiary of the UK-based Daily Mail and General Trust. At all times material, plaintiff was an employee of Defendant Daily Mail. Okay. Material facts. Plaintiff's employment and outstanding performance at Defendant Daily Mail. In or around February 2022, plaintiff began working for Defendant Daily Mail as senior U.S. entertainment reporter. In that role, plaintiff investigated, developed, and published exclusive entertainment news stories regularly covering high-profile celebrities and industry events. Plaintiff consistently performed at a high level throughout his employment, generating several million page views each month and publishing stories which were frequently republished by news outlets around the world. In fact, in or around October 2024, plaintiff received a meritorious raise from editor-in-chief Katie Davis and managing editor Richard Ellis for his excellent work and high traffic contributions, which increased his salary from $100,000 to approximately $122,120. Plaintiff also developed content for Defendant Daily Mail's flagship subscription platform, Mail Plus, where he became one of its highest performing contributors. Plaintiff's reporting on the Baldoni Lively matter and his involvement in the subsequent litigation. Okay. Plaintiff's success depended on cultivated relationships with celebrity publicists and industry sources, one of whom was actress Blake Lively's publicist, Leslie Sloan, who had previously provided plaintiff with information leading to numerous exclusive stories. In or around early August 2024, Defendant Daily Mail assigned plaintiff to investigate reports of tension between Ms. Lively and actor-director Justin Baldoni during production of the film It Ends With Us. On August 8, 2024, plaintiff contacted Ms. Sloan regarding those reports. During that conversation, Miss Sloane described Mr. Baldoni as the source of on-set conflict. She never stated that Mr. Baldoni had sexually harassed or assaulted Miss Lively. Then, on December 20th, 2024, Miss Lively filed a complaint with the California Civil Rights Department alleging sexual harassment by Mr. Baldoni. 2 days later, after reading a New York Times article discussing Miss Lively's complaint, plaintiff texted Mr. Baldoni's PR crisis manager, Melissa Nathan, contrasting Miss Lively's allegations in the CRD and the New York Times article with what Miss Sloane had previously told him, writing in pertinent part, Miss Sloane said, "The whole cast hates Mr. Baldoni. This has nothing to do with Miss Lively, and now she's saying that Miss Lively was sexually assaulted. Why wouldn't she say anything about that then?" Now, you see, the issue here is, right, is it does sound like, if you read that text, like, I put myself in the position of Brian Friedman, or Melissa Nathan even, and you get that text from James Vituscka, and it sounds like, you know, Miss Sloane said is the start of the entire text. And now she's saying that Miss Lively was sexually assaulted. The problem I had with James Vituscka during all of this is he then tried to backtrack and say, well, Leslie Sloane never said that she was sexually harassed or sexually assaulted. But if you read this text in the way he's written it, and bearing in mind his entire career is around writing, it does read that, you know, Miss Sloane said da 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 da, and now she's saying that Miss Lively was sexually assaulted. Why wouldn't she say anything about that then? Because he tried to say, no, what I meant by that was Lively said that she was sexually assaulted. And then he's like, oh, I shouldn't have said assaulted, I should have said harassed. But then you got this bit afterwards then that says, why wouldn't she say anything about that then? He wasn't speaking to Blake Lively back then. He was speaking to Leslie Sloane. This is why I don't buy a lot of his guff. And I don't know what's true anymore with him. Because, you know, I think Wayfarer, I think Brian Friedman read that text in exactly the same way as I've just read it, as I've always read it. So we'll see. Okay, let's continue. Although plaintiff inadvertently used the phrase sexually assaulted instead of sexually harassed, plaintiff clearly established that Miss Sloane told him the dispute had nothing to do with Miss Lively, and that he never claimed Miss Sloane had mentioned sexual harassment or assault to him. You see, that's what he's saying. No, but she never said this. I used the wrong word, but also just to add, then that's just to confuse the situation even more. He used the wrong word, but then also I never said that Leslie Sloane mentioned sexual harassment or sexual assault. But when you read the text, that's how it reads. It reads that, you know, well, Leslie Sloane is saying that Blake Lively was sexually assaulted. But she didn't say anything when I talked to her months ago. Why wouldn't she say anything about it months ago when I was talking to her? Now she's saying that he's... And I think the fact that he got the word wrong as well, you know, just made things even worse. Okay, so I'll stop digressing now, sorry. Okay, on December 25th, 2024, plaintiff again reaffirmed his communications with Miss Sloane in a group text with Miss Nathan and Mr. Baldoni's attorney, Brian Friedman, stating in relevant part, never once did Miss Sloane mention anything about the sexual harassment. But again, the text message at this point now says sexual assault. Plaintiff's communications with Mr. Friedman occurred in the ordinary course of his reporting on a rapidly developing and highly public controversy. Like investigative reporters covering contentious matters, plaintiff communicated with individuals representing different perspectives to understand and verify competing accounts. Plaintiff did not anticipate that portions of those communications would later be selectively quoted in litigation while omitting his subsequent clarifying statements. Nevertheless, on December 31st, 2024, Mr. Friedman filed a lawsuit against the New York Times that included screenshots of plaintiff's text messages, name and photograph. When plaintiff learnt that these texts were included in the lawsuit, he immediately contacted Mr. Friedman and Miss Nathan, demanding removal of his name and photo. On January 2nd, 2025, Mr. Friedman filed an erratum to the lawsuit, redacting plaintiff's name and photo from the text message screenshots. On January 16th, 2025, Mr. Friedman filed a lawsuit against Miss Lively and Miss Sloan, alleging defamation. In doing so, he selectively quoted plaintiff's December 22nd, 2024 text message to Miss Nathan, stripped it of its surrounding context, and falsely alleged that, per plaintiff, Miss Sloan had told him Miss Lively had been sexually assaulted by Mr. Baldoni. Plaintiff never made that statement. By publicly attributing false statements to plaintiff, the litigation thrusts plaintiff into the centre of a nationally publicised dispute. Those events in turn became the basis for defendant Daily Mail's subsequent efforts to control plaintiff's legal representation, dictate the contents of his sworn declaration, and influence how he responded to judicial process. And one thing I will say, I've always sung Brian Friedman's praises. I think he did a phenomenal job on bringing back all the public support very quickly to Wayfarer. When, it looked like it was going to be crushed. He is a good attorney. But if he has misrepresented text messages, I'm just keeping an open mind here, right? I'm painfully aware that the allegation that he's done that has come from James Vituscka, of all people. But if Brian Friedman has done that, then that is problematic. That is not good lawyering. And also, it's a bit hypocritical, especially when they were complaining that Stephanie Jones and Blake Lively did exactly that with their own, the text messages that they stole from Jen Abel's phone. So if there's criticism there to be had, then I will be critical of Brian Friedman. But again, this is James Vituscka. I'm hoping this gets to discovery. I do know that Without a Crystal Ball was in contact with him, and she called him out for being a liar too, and misrepresenting communications. So, I sit on the fence. I'm skeptical of anything that James Vituscka says. Okay, so Mr. Ellis subjected plaintiff to sexual harassment and retaliation. On or about December 6, 2024, Mr. Ellis randomly summoned plaintiff to his office, falsely accused him of scratching the elevator door, and asserted that repairs would cost approximately $2,350. Plaintiff denied scratching the door and requested that Mr. Ellis review the security camera footage. Mr. Ellis refused plaintiff's request. And it's quite a simple. So, yeah, if that's a reasonable request from James Vituscka. So if the companies refuse to do that, that's something to be curious about. However, later that day, Mr. Ellis admitted to plaintiff via Slack that there was insufficient evidence to blame him, writing, "As your judge, jury, and executioner," that's an interesting start, "I rule that the evidence is not clear beyond reasonable doubt. So let's put all of this behind us and get on with our lives." That evening, Independent Daily Mail held its annual holiday party at the Somewhere Nowhere Lounge. Shortly after plaintiff arrived, Mr. Ellis approached him, looked plaintiff up and down, and stated in a seductive and flirtatious manner, "I'm still trying to figure out a way for you to repay me for the elevator." Plaintiff understood the remark to be sexually suggestive. He stood silently and refused to engage, fearing retaliation if he confronted the managing editor. Executive editor Emma Powell noticed plaintiff's discomfort and intervened by pulling plaintiff away under the pretense of taking group photographs. Nevertheless, following plaintiff's rejection of Mr. Ellis's sexual advance, Mr. Ellis's treatment of plaintiff changed markedly. As set forth below, Mr. Ellis then engaged in a sustained pattern of hostility toward plaintiff that culminated in plaintiff's termination. Okay. So what he says I'm still trying to figure out a way for you to repay me for the elevator. Yeah, that could actually be seen as sexual harassment if it's kind of meant in a manipulative, blackmailing type way. It's possible. I mean, again, it sounds more heavy than anything Blake Lively went through. Looked him up and down and stated in a seductive and flirtatious manner. Yeah, I mean, these are, again, they're subjective, but if he felt sexually harassed, then that's enough. Okay. Defendant Daily Mail prevented plaintiff from obtaining independent counsel and attempted to control his participation in the Lively Baldoni litigation. In or around April 2025, Ms. Sloane's counsel personally served plaintiff with 2 subpoenas, one requiring production of documents and another requiring plaintiff's deposition testimony in the Lively Baldoni litigation. Defendant Daily Mail was also subpoenaed for documents related to that same litigation. Recognising that his personal legal interests could diverge from Defendant Daily Mail's corporate interests, plaintiff immediately informed Defendant Daily Mail's in-house attorney, Beth Lobel, that he intended to retain his own counsel to advise him regarding the individual subpoenas. However, Miss Lobel told plaintiff not to get his own lawyer because doing so would betray the company. She further warned plaintiff that it is best not to have emails creating a record. Defendant Daily Mail's efforts to prevent plaintiff from retaining independent counsel were not limited to its legal department. Deputy Editor Chelsea Richsell likewise instructed plaintiff that retaining outside counsel would be a mistake, and that he needed to put the company first, reinforcing Defendant Daily Mail's directive that plaintiff subordinate his own legal interests to those of the organisation. Under this combined pressure, plaintiff did not retain independent counsel and instead relied upon attorneys who prioritized Defendant Daily Mail's rights over his. Throughout April 2025, Ms. Lobel repeatedly made statements intended to pressure plaintiff into believing he was personally responsible for Defendant Daily Mail's legal expenses and to discourage him from exercising his independent judgment. For example, Ms. Lobel told plaintiff, "This is your fault for getting us involved. It should be a lesson to you. This should be a lesson in empathy on how to treat people you interview. Your conversations with Mr. Friedman have nothing to do with Daily Mail, and this is costing the company so much money to represent you." Defendant Daily Mail's efforts to control plaintiff's legal representation soon expanded into efforts to control the manner and substance of his response to the subpoenas. For example, in or around late May through early June 2025, despite plaintiff's explicit objections, Defendant Daily Mail coordinated with Ms. Sloane's counsel to respond to plaintiff's subpoenas through a sworn declaration, rather than by permitting plaintiff to produce documents and testify at a deposition. Plaintiff repeatedly objected to the use of a sworn declaration in lieu of responding to the subpoenas through document production and deposition testimony, given the antics of Mr. Baldoni and his legal team, along with the missing context which had already harmed plaintiff's reputation. Plaintiff consistently asked to preserve his ability to provide truthful testimony pursuant to the lawful subpoenas. Defendant Daily Mail pressured plaintiff to sign a declaration he believed was false or misleading. Throughout the drafting process, plaintiff repeatedly identified statements in the proposed declaration that he believed were false, misleading, or unsupported by his own knowledge. For example, on May 22, 2025, plaintiff objected to language stating that he regretted his actions because that language did not accurately reflect his views. Then on or about June 4, 2025, plaintiff participated in a Zoom meeting with defendant Daily Mail's legal team, again without independent counsel present on his behalf. After counsel continued pressing for the disputed language, despite plaintiff's objections, plaintiff again asserted that he would not agree to characterize his actions as something he regretted. Despite plaintiff's repeated objections, the word regret still appeared twice in the final declaration. Plaintiff then Slack messaged Miss Powell and Miss Ritschel. I was super uneasy with how I was being gaslighted into thinking I was the one to blame. I have really no other option than to sign the declaration because Miss Sloane is really coming for me and wants to silence me. On the morning of June 5th, 2025, plaintiff learned that if he signed the declaration, Miss Sloane would withdraw the subpoenas served upon plaintiff, except as to certain communications with Mr. Friedman and the subpoena served upon defendant Daily Mail. This reinforced plaintiff's belief that the declaration was being used as a negotiated litigation device rather than simply to memorialize his truthful recollection. Later that day, plaintiff also objected to language stating that he did not authorize Mr. Baldoni or his counsel to include his text messages in their filings, explaining that he could not truthfully state what had or had not been authorized. When Miss Lowell insisted that plaintiff sign, he again refused to sign the declaration with language that he did not authorize publication of his text messages. Counsel nevertheless continued urging plaintiff to execute the declaration. Feeling like his objections were being ignored, plaintiff then emailed Miss Ritzel and Miss Powell. I had to send this because I cannot sign something unless I am 1,000,000%. That afternoon, Miss Lowell entered the newsroom and hostilely asked plaintiff, have you signed the declaration? Why have you not signed it? You need to sign it. There is a court deadline. When plaintiff requested that Miss Davis review the declaration first, Miss Lowell replied, why would Miss Davis need to see this? She knows nothing about this lawsuit. Plaintiff then texted Miss Powell, I literally could never work again. I don't think I'm going to sign it. My gut says no, I'm being yelled at for not signing it. Ms. Ritzel then instructed plaintiff, sign it. Miss Davis just asked that you sign it and get it done. Plaintiff responded, this is so ridiculous. No one wants to understand or listen to why I don't want to do it. Defendant, I'm confused now because I'm just going to interject here a little bit. I am a bit confused because what I'm hearing so far to this point is exactly what I heard at the time is, he started this earlier on by saying, I never authorized my messages to be used in litigation. But then when he's asked to sign a declaration saying pretty much that, he doesn't want to sign it because he can't swear that he said that. And likewise, at the start of this, Friedman and Baldoni and Wayfarer were the bad people with, antics and, misrepresentation and misleadingly stripped of context, blah, blah, blah. But now he's saying that Sloane and her team were also, it's like, what is going on? This guy really confuses me. It almost feels like, he's hedging his bets a bit. Like, so if he gets another job and he has to work with, these celebrities again, these publicists again, he's kind of hedging his bets and batting for both teams a little. And I don't love that. Defendant Daily Mail abandoned plaintiff while publicly exploiting the declaration, and plaintiff engaged in further protected whistleblower activity. On or about June 5th, 2025, at approximately 3:30, after hours of escalating pressure from defendant Daily Mail's legal and editorial leadership, plaintiff reluctantly signed the declaration while seated next to his colleague Diana Cooper. Immediately before signing, plaintiff wrote, I don't feel completely comfortable in doing this, on a piece of paper and placed it next to the declaration before executing it. He then showed both the note and executed declaration to Miss Cooper. The executed declaration stated in relevant part, In these text messages, the use of the phrase sexually assaulted was a mistake. I meant to say sexually harassed. I regret this error. I did not authorize Mr. Baldoni or his counsel to include my text messages in their filings. I regret that private text messages were made public. Both uses of the word regret, as well as the statement that plaintiff did not authorize publication of his text messages, remained in the declaration despite plaintiff's repeated written objections. How can you not regret using sexually assaulted instead of sexually harassed? I mean, he himself admits that's a mistake, so how can you not regret making a mistake? Again, I'm really confused by this, and he's about to talk about whistleblower activity, and I'm struggling to figure out what he was blowing the whistle on. Plaintiff's objection to signing a declaration under coercion amounted to protected whistleblower activity. Later that evening, plaintiff learned that Deadline was preparing a story concerning the declaration based on information provided by Miss Sloan. Concerned that the reporting would falsely portray him, plaintiff immediately notified defendant Daily Mail's legal department, requested legal assistance, and asked for an opportunity to respond before publication. Plaintiff was then referred to Head of Internal Communications Mark Ryken. The next morning, on June 6, 2025, plaintiff emailed Mr. Ryken and asked that defendant Daily Mail contact Deadline to ensure that plaintiff could respond before publication of any false or misleading story concerning him. However, Mr. Ryken did not contact Deadline. Despite plaintiff's request, major news outlets including People, Page 6, The Wrap, and Deadline published stories portraying plaintiff as having misspoken or characterizing the declaration as an admission of error. Later that evening, plaintiff text messaged Mr. Ryken. I know you advised me to let it go and it will eventually pass, but this lie has already damaged my reputation and will have a devastating impact on my career and the relationships I have with all my trusted sources. Miss Sloan sending this to various outlets, which are spinning this and painting me as a liar. Mr. Ryken explained that Chief HR Officer Richard Morgan instructed him not to engage, stating, I understand and I want to help, but the mandate to not engage has come from the top. It will open us up to potentially more trouble. My hands are tied. Later that evening, plaintiff texted Miss Ritzel and Miss Powell. I just got done talking to my therapist for a while, and I think that right now would be a good time to take a week off work. I do not want to have a meltdown at work over shit I cannot control right now. Miss Ritzel responded, I completely get it. Take the week, turn your phone off, and take care of yourself. I don't want you to worry about any of this. It will work out. From June 6, 2025 to June 16, 2025, plaintiff took approved medical leave as recommended by his therapist. In or around early June 2025, plaintiff retained attorney Mark Garagos of Garagos and Garagos as independent counsel. It's important to kind of just point out that Mark Garagos is a close friend, mentor, and the attorney of Brian Friedman. Around the same time, plaintiff received another subpoena from Mr. Friedman. Plaintiff advised defendant Daily Mail that he did not want to object to the subpoena and instead wished to provide deposition testimony. Nevertheless, Daily Mail's counsel prepared and filed objections on plaintiff's behalf over plaintiff's express wishes, continuing defendant Daily Mail's pattern of overriding plaintiff's decisions regarding his own legal representation and participation in the federal litigation. On June 15, 2025, Mr. Garagos sent defendant Daily Mail a claim letter notifying the company that plaintiff was a protected whistleblower under New York law and that any adverse employment action taken against him would constitute unlawful retaliation. So I'm guessing at this point the retaliation is over whistleblower, not the sexual harassment. Again, this is not that clear. Nevertheless, defendant Daily Mail then began to retaliate against plaintiff. For example, The next day, Dependent Daily Mail materially changed the way plaintiff's work was supervised and evaluated. So, just to pivot ourselves, he was sexually harassed in December 2024. We're now in June 2025. So far, he has not mentioned that there has been any retaliation for rejecting the unwanted sexual advances of Mr. Ellis. We haven't even heard Mr. Ellis's name again since. But now, suddenly, over 6 months later, there's going to be retaliation from Mr. Ellis. And he's going to try, James Vituscka is about to try and link it to the sexual harassment that happened the previous December. It sounds like he's pulling a bit of a lively here. I'm not being dismissive. He may well have been sexually harassed, but the retaliation, I mean, nothing's happened up to this point. And now all of a sudden, there's going to be retaliation, even though there's plenty of other shit going on. And it's going to come down to that moment back in December. I'm really confused by this. It just sounds like, Daily Mail are unhappy with him for whatever reason. And he's going to say, well, yeah, but this event that happened months and months and months ago, we're going to call it retaliation because of that. Which is effectively what Blake Lively did. Okay. Specifically, Dependent Daily Mail required that all the plaintiff's article submissions be reviewed and approved by Mr. Ellis and the attorneys identified in plaintiff's claim letter. Then on June 26, 2025, Mr. Ellis left plaintiff a voicemail requesting a call. Plaintiff responded via email stating, I want to formally express that any adverse employment action taken against me at this point would be retaliatory, as I have an active and ongoing whistleblower complaint. Nevertheless, Mr. Ellis responded to the email, terminating plaintiff effective immediately, stating, you have repeatedly demonstrated a lack of integrity and poor judgment, which I don't disagree with, and we therefore cannot rely on you as a reporter going forward. However, Dependent Daily Mail's stated reason was pretext. Plaintiff was never counselled for any performance-related issues, let alone accused of lacking integrity and exercising poor judgment. Prior to engaging in protected whistleblower activity, rejecting Mr. Ellis's sexual advance, and requesting a reasonable accommodation. In reality, Dependent Daily Mail viewed plaintiff as a complainer and sought to prevent him from blowing the whistle in the future. Yeah, but blowing the whistle on what? Does anyone, actually understand what he's blowing the whistle on? Defendant Daily Mail continued to retaliate against plaintiff post-termination. On or about April 11th, 2026, Ms. Lively and Mr. Baldoni's legal teams filed a joint pretrial order containing their prospective trial witness list, wherein Ms. Lively named plaintiff. Shortly after, on or about April 15th, 2026, Dependent Daily Mail removed all references to plaintiff from its portfolio, which included roughly 500 articles and exclusives, as well as any associated links to his own portfolio. This retaliatory action effectively eliminated any professional attribution of plaintiff and destroyed the public record of his work of the past 3.5 years. Dependent Daily Mail would not have discriminated against plaintiff but for his sex and actual and or perceived disability. What disability? I don't understand what the disability is. He took some time off because he was having a rough patch, but I do not see he's not described any disability. Dependent Daily Mail would not have retaliated against plaintiff but for his request for a reasonable accommodation and protected whistleblower complaint. As a result of the acts and the conduct complained about herein, plaintiff has suffered and continues to suffer a loss of income, the loss of a salary, bonus, benefits, and other compensation which such employment entails. As a result of defendant Daily Mail's actions, plaintiff felt and continues to feel extremely humiliated, degraded, victimized, embarrassed, and emotionally distressed. As a result of defendant Daily Mail's discriminatory and intolerable treatment of plaintiff, he has suffered and continues to suffer severe emotional distress and physical ailments. As a result of the acts and conduct complained of herein, plaintiff has also suffered future pecuniary losses, emotional pain, suffering, inconvenience, loss of enjoyment of life, and other non-pecuniary losses. Defendant Daily Mail's conduct has been malicious, willful, outrageous, and conducted with full knowledge of the law. As such, plaintiff demands punitive damages as against defendant Daily Mail. Okay. Just before I go through the cause of action. So where I am, Roses Wild, you absolutely nailed it. He says, he does, kind of chop and change. Like, 1 minute everything is Brian Friedman's fault. The next minute is Leslie Sloane's. 1 minute I didn't allow my text, that it was unauthorized use of my text. I didn't expect him to do that. Then it was, well, I can't sign a declaration. I object to signing a declaration saying that they were used without my consent and knowledge. And not. It's like, what the hell is going on? And he's thrown in this subjective incident during a work night out where someone looked him up and down and spoke to him rather in a sexual, in what he perceived a sexual way. But everything, there was no retaliation until many months later, but he's going to link the two anyway. But whilst he's also saying that he's been retaliated against for sexual harassment, he's also claiming that he's a whistleblower of what I'm not quite sure of. What whistle was he blowing? But that also, the retaliation is due to that. So it's like, I'm getting really confused. And now we've got, he's been discriminated because of his sex. By who? I mean, he's a man. So when it comes to sex-based discrimination, that is, in the vast majority of cases, something that women experience, right? So who is discriminating him because he's a man? Because Mr. Ellis is also a man. So which women are discriminating him because he's a man? I've seen nothing in this complaint that has occurred purely for the fact that he is a male. If he's saying sexual harassment, then maybe. But isn't that a sexual identity thing? A sexuality thing as well? And then the disability. I have read nothing which points to a disability. I'm hoping that the causes of actions might explain that a bit. I just think that this is not a well-written complaint. There is not enough detail in here to explain things in more depth, and we're bouncing around all over the place. Like, it's gone in chronological order, but then we've jumped from the text messages and what he said, Leslie Sloane said, straight to a works night out where he's sexually harassed, and then we've come back to the declaration, and then we've come back to, oh, I've been sexually harassed, and I've now got whistleblower status, and it's all over the place. Chronological order is great, but I would have preferred that he had broken it down in terms of the events. So, like all of the stuff relating to Baldoni Lively, Leslie Sloane, and whistleblower, they all sound related. Like, tell me about that in one part, which maybe has subparts to break it up a little bit, and then also say, and on this day, we had a works night out, and this happened. This was what he said to me, and this is how I felt. And then, go on and tell me then how did he retaliate specifically for that? Because at the moment he's mixing it up here. Like, well, I've been retaliated because I'm a man, because I'm, I've got a disability, because I'm a whistleblower, and because I was, I did rejected unwanted sexual advances. It's like, you've been retaliated for each and every one of those things. Well, how much retaliation? Like, how were you retaliated for, and for what thing? And this information is quite important. It's important to break it down. You can't just lump everything in and hope for the best. This complaint is, as it's written, is incredibly weak. It's got quite significant holes. This would not be difficult for the Daily Mail to file a motion to dismiss for failure to state a claim, because I can't actually work out what his claims are in this. So we'll look at the causes of action. As a first cause of action under state law, whistleblower retaliation. Plaintiff repeats, reiterates, and realleges each and every allegation, of which you have not made, by the way, made in the above paragraphs of this complaint, as if more fully set forth herein at length. Okay. New York Labor Law, Section 740, states in pertinent part, prohibitions: an employer shall not take any retaliatory action against an employee, whether or not within the scope of the employee's job duties, because such employee does any of the following: A. Discloses or threatens to disclose to a supervisor or to public body an activity, policy, or practice of the employer that the employee reasonably believes is in violation of law, rule, or regulation, or that the employee reasonably believes poses a substantial and specific danger to the public health or safety. B. There's nothing. C. Objects to or refuses to participate in any such activity, policy, or practice. Right, okay, so he's relying on New York Labor Law Section 740, subsection 2A and 2C. Defendant Daily Mail engaged in an unlawful employment practice by retaliating against plaintiff because he reported, disclosed, and or objected to or refused to participate in a practice of his employer which he reasonably believed to be a violation of law, rule, or regulation. As a second cause of action, see, that told me nothing. As a second cause of action under state law, discrimination. Plaintiff repeats, reiterates, and realleges each and every allegation made of this complaint, as if more fully set forth herein at length. Executive Law, Section 296, provides that 1. It shall be an unlawful discriminatory practice, A, for an employer or licensing agency because of an individual's sex and disability, to refuse to hire or employ, or to bar or to discharge from employment such individual, or to discriminate against such individual in compensation or in terms, conditions, or privileges of employment. Defendant Daily Mail engaged in unlawful discriminatory practice by discriminating against plaintiff on the basis of his sex and actual and or perceived disability, together with creating a hostile work environment, retaliation, sexual harassment, and unlawful termination. Plaintiff hereby makes a claim against defendant Daily Mail under paragraphs of Executive Law, Section 296. As a third cause of action under state law, retaliation. Plaintiff repeats, reiterates, and realleges each and every allegation made in the above paragraphs of this complaint, as if more fully set forth herein at length. New York State Executive Law, Section 296, subsection 7, provides that it shall be an unlawful discriminatory practice for any person engaged in any activity to which this section applies to retaliate or discriminate against any person because he or she has opposed any practices forbidden under this article. Defendant Daily Mail engaged in an unlawful retaliatory discriminatory practice by retaliating and otherwise discriminating against plaintiff on the basis of his sex and actual and or perceived disability, together with creating a hostile work environment, retaliation, whistleblower retaliation, sexual harassment, interference with a protected right, and unlawful termination. Plaintiff hereby makes a claim against defendant Daily Mail under all of the applicable paragraphs of the Executive Law, Section 296. Okay, we're near the end now. So, as a fourth cause of action under the New York City Administrative Code, discrimination. So we're going for all the discriminations here. Plaintiff repeats, reiterates, and realleges each and every allegation made in the above paragraphs of this complaint as if more fully set forth herein at length. The Administrative Code of City of New York, Title 8, provides that it shall be an unlawful discriminatory practice, A, for an employer or an employee of agent thereof, because of the actual or perceived sex and disability of any person, to refuse to hire or employ, or to bar or to discharge from employment such person, or to discriminate against such person in compensation or in terms, conditions, or privileges of employment. Defendant Daily Mail engaged in an unlawful discriminatory practice in violation of New York City Administrative Code Title 8 by creating and maintaining discriminatory working conditions and otherwise discriminating against plaintiff on the basis of his sex and actual and or perceived disability, together with creating a hostile work environment, retaliation, sexual harassment, and unlawful termination. Okay, just to kind of, before we move on to the retaliation side, just a word on discrimination. And some of you who are kind of watching my videos in the Celeste Smith case against Steve Sarowitz and Wayfarer, of which my next video will be on, may have heard me say this. Discrimination in human rights is, it's like it was one of my my specialist areas in my postgrad studies, and I covered it a lot in practice as well. So it is not enough, right? If I use race as an example, okay, and this is just an example, so I hope no one's kind of offended, but and this could apply to any, but just as an example, like it with Celeste Smith, in that case, she is saying, I mean, she's pulling out all of the discrimination cards. The only one that's missing is sexuality, right? So we have with Celeste Smith race, religion, sex, age. I'm going to leave out disability because she had bruised ribs. That's not a disability by any stretch of the imagination. Okay. So race, religion, sex, and age, right? She's claiming all of those discriminations are the reason that she lost her job. Now, she can be a woman of color, someone who holds religious beliefs. She can be of a certain age and a certain sex, right? The fact that you hold the protected characteristics and lost your job or had to have a disciplinary or was demoted or whatever happened does not mean that you were discriminated against, right? And you cannot just, say, right, okay, well, I've been fired from my job, I'm black, therefore I've been racially discriminated against. That's not how that works, okay? You have to allege and prove the link. Yeah, so you have to prove that you were fired because you were black, or because you were over a certain age, or because you were a woman. And it is incredibly hard to do. Like the religion, she's saying, well, I was replaced by a younger male who's not a Muslim and he's white. That is what she's saying, right? Now, she has not given us any more information. Who was the person that she replaced? Did she replace someone who has all those same characteristics as her? Probably not. But she refers to a young white male who is a Baha'i faith, right? Whereas she follows a Muslim faith. Now, she doesn't say that this young person's age. She doesn't really give us much at all other than he's a young male. But even still, right, that does not mean that she has been discriminated against. Like, I have no faith in her lawsuit. But, the starting point for these discrimination cases is, you may have the protected characteristics, but you also have to make the connection that you experience adverse employment action because of those. You can't, just, if you have terrible work ethics, Like in the Wayfarer Foundation's situation, they actually wound down. So what was she replaced? Because the job really wasn't there. And she was also kind of quite the complainer as well. Um, you know, when we actually read her complaint, they were at an event where Steve Sarowitz was defending his religion. Um, and he's the company had been very, very warm to all religions, right? We looked at their Instagram. They're very embracing of all religions. They acknowledge all the important religious days, the diversity. I've never seen a more diverse company in terms of the people they hire and celebrate. And the roles, the events they get involved with as well. And I find it wild that this lady is screaming discrimination. I've never seen a company so diverse and so welcoming of all cultures, all religions, all people from all backgrounds. And it's quite disheartening as well because, you know, it seems like in those situations you see, obviously there is a lot of discrimination. It happens. It needs to be challenged. It needs to be stamped out. Absolutely. But when you've got companies who really go above and beyond and they still get people accusing them of discrimination and not being diverse when they are very when they're very much their whole ethos is anti-discrimination and they are very diverse. It kind of devalues the efforts that they're making. But what James Vitusca's got to do here is he is saying, well, I've been discriminated because of my sex. So that may be the unwanted advances by another male. And then my actual or perceived disability. Right? So you haven't got to have an actual disability. You could have a perceived disability. But I don't understand what is supposed to be his disability here. He hasn't made that clear. So but even if he has got those characteristics, simply saying, look, I lost my job because they discriminated against me because I have these characteristics is not enough. You do have to actually prove you lost your job because of this, not you lost your job and you just happen to have those characteristics. And I think that there's a lot of confusion there, we would be living in a rather insane world because most people have got a characteristic or another, I mean, half of the world is female. Many have, have a, they have a religious belief. Many have a disability. And if every time one of those people experienced like what they perceived to be adverse employment action, where in reality it was actually maybe a disability, it was a disciplinary for, I don't know, maybe they didn't meet their targets or something, or they were persistently late to work. Just poor attitude and poor work ethics. If if they could if they could sue every time they were basically the leadership, applied leadership, then that would be such a wild situation to be in. So you've actually got to connect the two. You can't just state, well, I've got the protected characteristics, I've been fired, and that equals I've been discriminated against. The world just doesn't work like that. Employment law doesn't work like that. So, and that was a bit long-winded, but I really wanted to kind of make that point. Like not every person, not every black person, for instance, who has lost a job will have lost that job because of racial discrimination. It absolutely happens. And where there is evidence of it, challenge it. I represented loads of people who have done that. My specialism really is towards disability. I represented SEND children for pro bono, so it was for free. I represented special educational needs and disabled children with admissions processes, appeals, tribunals, and so on and so forth, their legal rights, especially in education. And I've done it for people who are in the workplace as well. But yeah, it's I'm trying to explain it. It's just I think what is annoying me though about this complaint is I just don't know what he's complaining about. Like, what about his sex? What about his disability? What is his disability? And I'm just not seeing it. Like, I don't understand what he's whistleblown either. Like, it's just a lot. Like, this complaint is 20 plus pages long, and it tells me nothing, and it seems to contradict itself as well, which was the whole reason I was really put off by James Vituscka in the first place over a year ago. So I thought I'd read this and be further forward and understanding James Vitusca's role last year. I'm not. I'm not even a bit further forward. I still don't understand what happened, what's true, what's not true. And that really pisses me off. Okay, fifth cause of action. Right, sorry, that was a bit of a long-winded, but I'm trying to explain the law, try and take the opportunity to explain the law and how I think he's going to struggle here. As a fifth cause of action under the New York Administrative Code, retaliation. Okay, plaintiff repeats, reiterates, and realleges each and every allegation made in the above paragraphs of this complaint, as if more fully set forth herein at length. The New York City Administrative Code, Title 8 through 107, subsection 7, provides that it shall be unlawful discriminatory practice for any person engaged in any activity to which this chapter applies to retaliate or discriminate in any manner against any person because such person has 1. Opposed any practice forbidden under this chapter, 2. Filed a complaint, testified, or assisted in any proceeding under this chapter, 3. Commenced a civil action alleging the commission of an act which would be an unlawful discriminatory practice under this chapter. Dependent Daily Mail engaged in an unlawful and retaliatory discriminatory practice by retaliating and otherwise discriminating against plaintiff on the basis of his sex and actual and or perceived disability, together with creating a hostile work environment, retaliation, whistleblower retaliation, sexual harassment, interference with a protected right, and unlawful termination. As a sixth cause of action under the New York City Administrative Code, interference with protected right, plaintiff repeats, reiterates, and realleges each and every allegation made in the above paragraphs of this complaint as if more fully set forth herein. So, the Administrative Code of the City of New York provides it shall be an unlawful discriminatory practice for any person to coerce, intimidate, threaten, or interfere with, or attempt to coerce, intimidate, threaten, or interfere with any person in the exercise of or enjoyment of, or on account of his or her having aided or encouraged any other person in the exercise or enjoyment of any right granted or protected pursuant to this section. Defendant Daily Mail violated this section cited herein as set forth by interfering with plaintiff's right to be represented by counsel. And if they did interfere with his right to be represented by counsel, then yes, absolutely, they shouldn't have done that. Defendant Daily Mail further violated the section cited herein as set forth by interfering with plaintiff's statutory right to testify in a court proceeding pursuant to a duly issued subpoena. Wherefore, plaintiff respectfully requests a judgment against Daily Mail. A. Declaring that Defendant Daily Mail engaged in an unlawful employment practice prohibited by all these acts by discriminating against plaintiff on basis of his sex and actual and or perceived disability, together with creating a hostile work environment, retaliation, whistleblower retaliation, sexual harassment, interference with a protected right, and unlawful termination. B. Awarding damages to plaintiff for all lost wages and benefits, past and future, back pay and front pay, and to otherwise make plaintiff whole for any losses suffered as a result of such unlawful employment practice. C. Awarding plaintiff compensatory damages for mental, emotional, and physical injury, distress, pain, and suffering, and injury to reputation. D. Awarding plaintiff punitive damages. E. Awarding plaintiff attorney's fees, costs, and expenses incurred in the prosecution of the action. F. Awarding plaintiff such other and further relief as the court may deem equitable, just, and proper to remedy Dependent Daily Mail's unlawful employment practices. So, plaintiff requests a jury trial on all issues to be tried, wherefore plaintiff demands judgment against Dependent Daily Mail in an amount to be determined at the time of trial, plus interest, punitive damages, attorney's fees, costs, and disbursements of action, and for such other relied on as the court deems. I think that's supposed to be and for such other relief as the court deems just and proper. Okay. So that was a lot of nothing. I've already expressed a lot of what I think of this as I've gone through it, so I'm not going to, go over it again and repeat myself. What I am interested, though, is how the Daily Mail respond, because I think that might give us more information. I'm a flipping expert with the law, and I'm not seeing what he's claiming here. I'm not seeing it. Yeah, it seems like he's still the same James Vituscka from last year. Okay, guys. Let me know what you think, though. If I'm missing something, I feel like I shouldn't be confused about this complaint. So if I'm missing something, please let me know. But I'm just reading it as, I said he couldn't do this, but also I can't sign a declaration to swear that I didn't say he could do this. And it's like, what? Because if he did not have authority to use the text messages, Friedman did not have that authority, you did not give permission, and you had a bitch fit when he did use them, then why don't you just sign a declaration saying he used them without my consent and my knowledge? Why can't you swear to that if that's what happened? And this is what confuses me, and this is why I'm so suspicious of James Vituscka, but I still keep an open mind. It's just, this is 20 pages of complete crap from what I read. It tells me so little. I'm actually quite annoyed that I've spent time reading it now. But again, I want to see what Daily Mail say. I would love to see what the discovery is. Yeah, I think that's the only way we're actually going to get to some of the truth of what happened. I'm still perplexed by what the fuck James Vituscka's involvement was last year. So I'm going to follow this case out of curiosity to know what was he, what was his involvement? What part did he play in this, like behind the scenes? Because at the moment he's having a tantrum because he got, in his words, dragged into this lawsuit. No, sorry, mate, you inserted yourself in this lawsuit. I got fucking dragged into this lawsuit. I got dragged into it, as did 106 other content creators who just merely commented on this case, and we all got fucking subpoenaed. We weren't involved. We weren't texting with people, most of us anyway, that I know. This guy has no clue. The one thing I do have an issue with, though, is obviously if he wanted to retain legal counsel for the whole situation, he'd been subpoenaed for both documents and for a deposition, so on and so forth. And if he should have had his right, his entitlement to retain counsel, independent counsel, respected. If the Daily Mail, blocked him from doing that and told him he couldn't do it, I do have an issue with them for that. They shouldn't have done that. Everything else, though, I don't know. Yeah, let me know what you think. I will do a video, I think possibly tomorrow now, on the Celeste Smith, Steve Sauerwitz update, and Lively was supposed to respond to Jed Wallace to his appeal, and it didn't come. So I'm wondering where that is. I will check the docket though, and if something drops, I will cover that. Thanks for listening, guys.